Head of Scientist, Technical, Administrative Staff, YP, SRF, and other contractual staff. I welcome you all in IP Awareness Week program. Today with us is a well-known speaker, come expert in patent filing. She is Madam Vidisha Garg. I welcome you, ma'am. And to give a brief introduction about her, she is currently associated with partner with Anand and Anand, which is active firm which is working in the field of patent, and she is working from there last 17 years. She is a gold medalist in organic chemistry from the University of Lucknow, and she is also qualified CSR UGC NET. And with his expertise in patent, she is also a academician previously, and she has been awarded TIFAC scholarship for IPR, and also she is involved in many type of patent filing related to industries like pharmaceuticals, agrochemical, industry, chemical, metallurgy, metal, polymer, nutrient product, nutritional aspect, drug delivery system, and life sciences, and even in biodiversity, which is one of the important aspect for us also. And she is also having a lot of publication in intellectual property light, and also authored few of the in reputed journals. She has published few research papers also, and currently she is looking after pre-grant and post-grant opposition matters, and also her personal involvement in various foundation like APPI, FICPI, APPA, and also admitted in member of Bar Council of Delhi. And we are also working with her in regarding in filing patent, and she is closely involved with ICR and training in many training programs of scientists. So this is a very brief about her. Lot of achievements she is having. So I welcome her, madam. We are scientists here working in Indian Institute of Soil and Water Conservation, particularly on aspect of water conservation and soil preventing soil erosion and other aspect of soil, and associated with farmers in many activities. So we are here to listen to you regarding how we can improve the topic of today's topic regarding patent, copyright, and last lecture I also want to tell you that we have one last lecture by Dr. H.S. Chawla, where he has discussed about overview of all IPR type of categories. So over to you, ma'am. The platform is yours. Thank you. Thank you. And your voice is not coming. Please unmute, madam. Please. Your voice. Please unmute, madam. Unmute.
Sorry. Thank you, Dr. Anupam. Good afternoon to all the dignitaries and all the scientists present here. I thank you, Dr. Anupam, for this opportunity. But as you just mentioned, you had a lecture by
Dr. H.S. Chawla.
From S.S. Rana, and he has already given you an overview of patent, copyright, trademark, etc.
Yes.
So you gave a similar topic to me also. So do you want me to repeat this, or you want me to go?
Actually, ma'am, what is our objective is? Our objective is to, because that was pretty academic type, because your expertise is means how to, because we know how to file the means we know how are the protection, but little bit about practical procedure of filing regarding patent, because we are failing in that. And not as such filing, but how to initially write means how to proceed to the idea, how to we have to file it, or what we want to do, what not, because that part will be better dealt by you, because H.S. Chawla sir is more academician type of speaker, and you are more professional type, so that's why we have invited you.
Acha. So should I focus more on patents, or you want to discuss everything patent, trademark, copyright? Because if I will discuss all the things, then it will be again everything will be in very short thing, because in 1 hour.
Then madam, please discuss patent more, because.
So that would be better if we discuss patent. So I'll share my slide and I'll explain you as much as possible regarding patents, how to, it will also help you in your research work also.
Okay, please.
Okay, I'll just share my screen first. Are you able to see my screen, my slides?
Yes, sir.
Okay. So we first start with what is patent system, why we require a patent system, where we have to file our applications, and what is actually the procedure patent process in India. So basically,
and your slides are not visible now. Your screen is visible.
Not visible.
Not visible. Your screen is different screen has been shared. Please open the slide. Open the slide. Slides are not visible.
Okay, I'll share again. I'll share. Is the slide visible now?
Yes, it is visible.
Okay. Okay, no problem. So basically, what is patent? What we are looking for when we talk about getting a patent? So patent is basically, it is a legal right. It is a right provided under the law of our country, a law of India, and law of any of the country. So it is a legal right. So like we have right on our property, our house, our land, our jewelry, our clothes, our tangible goods, as we have legal right on our goods, tangible goods, we also have legal right on the things which we develop through our intellect, through our intellectual abilities, whatever we new innovations and inventions, creative ideas we develop, we can also get legal right on them by way of intellectual property rights. So patent is one of the intellectual property rights. Other rights, as you must be aware by now, are trademarks, copyright, industrial designs. Patent is also one, trade secrets, plant varieties, semiconductors and layouts. So all these are intellectual property rights, and patent is one of the most important, most strongest and most powerful intellectual property rights. So it is a legal right provided by the government. Patents or any of the intellectual property rights, these are considered as social contract between the inventor and the society. So inventor and society or government के बीच में, this is considered as a social contract. The inventor is required to disclose his invention, and in return he gets a monopoly for 20 years of time. These are negative rights because they provide you power to stop other people from using your invention or patented technology. Patent rights or any IP rights, these are territorial rights because they are provided by they are legal rights provided by the government of that country, so they are limited to the territory of the country where they are granted. And these are most importantly transferable rights, which means that like you can sell or give or donate or gift your movable properties to other, you can also do the similar transactions with your IP rights or patent rights also. So you can sell your patent, you can license your patent, you can donate or gift your patents. Therefore, the most important part of patent system or IP system is that it is a social contract. You need to understand this thing because I'm stressing upon it, because inventor is required to disclose his invention to the fullest. उसको पूरी अपनी invention disclose करनी पड़ेगी to the society or to the public by writing in the patent specification, and in return तभी जब सब कुछ when you will disclose everything, then only you will get the exclusivity or the legal right. Basically, the patent system is required for our society or for our country because it helps in development of innovation. It helps in development of market when new products and new services come into the market. It increases competition in the market. It provides improved services to the public, and it helps in improvement of the standards of living, and also it helps in technology transfer, diffusion of information. Therefore, it is considered as an important system to incentivize or to provide a market edge to the inventor or the innovator for a certain period of time, and in that time society develops. So as of now, we see that we are living in a creative society, technology based society, where every day we have new products and processes which are all protected by patent system and under this regime. So what rights generally a patent provide? Patent provide its right owner the right to prevent other people from following action. The actions are making. Nobody can make the patented product or use the patented process. Using, offering for sale. Nobody can offer for sale also. Nobody can use it. Nobody can sell it or import. Selling or importing the products that infringe their patent. So if you have a patent, so without your permission, nobody can do following actions: making, using, offering for sale, selling or importing the products without your permission. आपकी permission के बिना कोई ये action नहीं कर सकता. If somebody is doing such actions, you can file a case, infringement case against that person in the court. So basically, we can skip this slide. So patent system, we need to understand that for logo, for marks, the IPR which we require is a trademark. If you have done some literary work, you have done some artistic work, or you have made some sculpture, you have drawn some painting, you have written a book, a poem, all that are protected under copyright. If you have developed some industrial design, then it will be protected under industrial design. But if you have done some technology improvement, or you have developed you have made some change in the technology, existing technology, or you have developed something new or disruptive technology you have developed, then the protection which you require is a patent protection. So patents टेक्निकल एडवांसमेंट के लिए प्रोटेक्शन प्रोवाइड करते हैं. बट what patents actually provide protection for? वो किस चीज के लिए protection provide करते हैं? So patent provides protection to any invention, कोई भी invention which is a new product or a process involving an inventive step and capable of industrial application. So कोई भी invention जो न्यू है, न्यू प्रोडक्ट है या प्रोसेस है, कोई नया आपने प्रोडक्ट डेवलप किया, आपने कोई नया कॉम्पोजिशन डेवलप किया टू मेक सॉइल अ बेटर, टू रिटेन मोर वाटर और रिटेन मोर मॉइस्चर, या कुछ भी आपने नया प्रोडक्ट डेवलप किया, देन दैट एंड इट शुड बी न्यू, so it can be patented. Or you have developed some process, you have developed a process for preparing some compound or some soil composition. So if you have developed a product or a process, so दो चीज ही हो सकती है, process आप patent करा सकते हैं या product patent करा सकते हैं, and it should involve an inventive step and it should be capable of industrial application. I'll explain each of these terms in later slides. So therefore, invention क्या हो सकती है? What can be the invention? It can be any machine, apparatus, device या system, कुछ भी हो सकता है. It can be any method or a process of making these machine, apparatus, device, system or compositions. It can also be a software which is having a technical effect on a hardware. Improvements are also considered as patentable. तो आपने कोई improved product बनाया और you make an improved process. So these improvements are also considered patentable, provided they are new, involve an inventive step, and capable of industrial application. So the three essential criteria which come out from the previous slides are novelty, new. Newness is very important. The date on which you are filing your application for patent, it should not be known to anybody in the world. So your invention should be new, नई होनी चाहिए. Already existing चीज के लिए patent नहीं grant किया जा सकता. जो चीज the law considers that whatever is already known to public, that belongs to public. वो public की है. जो चीज सबको पता है वो सबकी है. जो चीज सिर्फ आपको पता है वो आपकी है. So your invention should be new. It should not be known to anybody in the world on the date of filing of the application. Then the second criteria is non-obvious, which means non-obvious to a person skilled in the art. Matlab, people who are working in the area of your technology. For example, if you are working in the technical field of soil conservation, so all the scientists who are working in this field, all the technicians who are working in this field, for them, your invention should not be an obvious modification of already known knowledge. Invention obvious नहीं होनी चाहिए. For example, मैं obviousness का एक बहुत basic kitchen से लेके example देती हूँ. We use sodium chloride और white table salt in our food. किसी वक्त में भी किसी मौके पे at a particular time, when you are cooking food or somebody is cooking, instead of NaCl, उनको नहीं मिला NaCl, so they put like pink Himalayan salt उन्होंने डाल दिया या black salt डाल दिया. So it is an obvious, it was this pink salt or black salt was an obvious substitute of sodium chloride or white table salt. So invention should not be obvious. इसका मतलब the purpose of the example was to explain what actually the term obviousness means. Invention should not be obvious to people who are skilled in the who are working in the same technical field. So कोई kitchen में जो काम करेगा वो कहेगा अरे कोई बात नहीं, नमक ही तो डालना था. We had to just add salt. So instead of white salt, you have added a pink salt or a black salt. So taste तो it is tasting a little bit same. So कोई नया dish नहीं बना. The dish remains the same because it was an obvious substitute. So invention should not be obvious for a grant of patent. The third criteria is industrial applicability, which means that your invention should be capable of being reproduced in any industry with same or similar characteristics. बार बार आपकी invention को, या if you have prepared come up with a new product, तो आपका product किसी industry में बार बार same specification के साथ reproduce हो सके. Or if your invention is related to a process, then your process must be such that it can be again and again used in that industry without any change and with same results. So in the criteria which become important for filing a patent application is novelty. Invention should be new on the date of filing of the application. Invention should not be obvious to people skilled in the art. जो लोग उस art में, उस technical field में काम करते हैं, for them invention should not be a mere workshop improvement. It should involve inventive mind, and it should have industrial applicability. What we generally say in patents to the inventors when we discuss about the invention, that simplicity is no bar to invention. Your invention can be very, very extremely simple. Just for example, even a hair clip, वो जो हम एक तार को मोड़ के we just make a U from a wire and use it as a hair clip, that is also considered as a patentable invention, provided it is novel, non-obvious, and industrial applicability. So we do not have to have a very rocket science invention, not very complicated invention. Invention can be very simple for grant of a patent. So India follows absolute novelty rule, which means that your invention should not be known to anybody in the entire world on the date of filing of your invention. there are certain moments or situations where invention is not considered as novel. Such instances are if your invention or something similar to your invention is already published in some other patent application, or it is published in some document. Document can be any journal, it can be any book, or it can be some article, it can be in the thesis, or it can be on available online on some blog or internet. If anything relating to, similar to your invention is already published in any document, in any sort of document, in any country, in any world, then the invention is not considered novel. Many a times, somebody else has already done work on same thing and they have filed a patent application, then also your invention will not be considered as novel. Sometimes your invention is a part of traditional knowledge. Like if you are using some herbs or something from already which have been traditionally used, so they may become a part of traditional knowledge, and traditional knowledge is not patentable in India or any of in most of the countries. So if your invention is covered under traditional knowledge, Ayurveda, Unani, or any other traditional knowledge of any community, then it will not be granted a patent. It will not be considered as novel. There are certain exceptions where your invention becomes known to people, but still patent office or the law allows you and considers your invention as novel. These situations are if somebody publishes the subject matter of your invention without your consent. कोई आपसे लेके आपकी invention और आपकी सहमति के बगैर without your consent publish कर दे, so under such situation it is considered that you have not authorized that person to for that publication. Therefore your invention will be considered novel, although it becomes public. वो publish हो गई है but फिर भी उसको novel माना जाएगा. Also, many a times there are situations when the public working of your invention is required for trial purposes. आपको पब्लिक में या किसी फार्म में फील्ड में खड़े होके ट्रायल करना है अपनी इन्वेंशन का, वे जहां बहुत लोग आपकी इन्वेंशन देख लेंगे, पर उस इवन इन दैट सिचुएशन योर इन्वेंशन इज कंसिडर्ड एज नॉवल, वो नॉवेल्टी डिस्ट्रॉय नहीं होगी. If many a times, because you are working in a government institute, you are required to communicate about your invention to government for some purposes. There may be several reasons. Such communication to government is also not considered as novelty destroying. वो माना जाएगा कि आपकी invention novel है, आपने किसी को नहीं बताया. Any communication to government is considered as not disclosed. If many a times you display your invention in some industrial exhibition or some exhibition notified by the government, or you read a paper in a learned society, or your invention gets published in the paper of the learned society, such reading of paper or exhibition of your invention or publication of your invention is not considered as novelty destroying, provided you file your application within 1 year from such disclosure. मतलब 1 साल के अंदर अंदर आपने जिस भी दिन पेपर रीड किया या when the day on which you displayed your invention, within 1 year you file your patent application and your invention will be considered as novel. So nowadays recently patent rules have come, and they are now officially providing the grace period of this 12 months. So what actually you need to do to protect your invention so that your novelty remains intact? So most important thing which you should not do is that you should not publish any article, press release, or you should not make any publication. You should not display your invention before you file the patent application. इसका मतलब ये है जैसे in the scientific world you say publish or perish, but IP के फील्ड में, इस लीगल फील्ड में we say first file a patent and then you publish your application. So if you will not first file your patent application before the disclosure, then actually the invention perishes. So first file a patent and protect your invention and then make any sort of publication. The second don'ts, or which the thing which you should not do, is that you should not sell any product or market any product before you file your patent application. Important do's is that if you have to make any disclosure of your invention, आपको अपनी invention के बारे में you have to tell to somebody, sign a non-disclosure agreement with that person or a confidentiality agreement. Sign an agreement that I am disclosing my invention to you under confidence of confidentiality and under an agreement of confidentiality that you will not tell about my invention to anybody else. So sign such kind of agreement, non-disclosure agreement, and then only discuss about your invention to the prospective buyer or whatever you want to whomsoever you want to make a disclosure. Then only make a disclosure of the invention. Otherwise, that person can go to the patent office and tell them that I already knew about this invention before this person filed the patent application. So सबसे पहले, the most important thing you should do is first file your patent application, then only make any sort of disclosure about the invention to anybody. And once you file the patent application, then only go forward with the publication of the articles in the journals. The next important criteria is the inventive step. Inventive step has been defined under the Act as the feature of the invention which involves technical advance as compared to the existing knowledge or having an economic significance or both, and that makes invention not obvious to a person skilled in the art. इसका मतलब है inventive step is that feature of the invention. Inventive step इन्वेंशन का वो पार्ट है विच जहां पे एक्चुअली टेक्निकल एडवांसमेंट आपने किया है. एज आई जस्ट सेड, पैटर्न्स आर फॉर टेक्निकल इंप्रूवमेंट्स और डेवलपमेंट इन टेक्नोलॉजी. वो द पार्ट of the invention where you have actually done the technical improvement or advancement, that is called the inventive step. Or if your invention is providing any sort of economic significance, then that economic significance, that part of the invention which is providing economic significance may be considered as inventive step. And your invention should be non-obvious to a person skilled in the art. Person skilled in the art को आपकी invention obvious improvement या modification नहीं लगना चाहिए. Workshop improvements and modifications are considered as obvious to a person skilled in the art. So patents are not granted to workshop improvements and modifications if there is a genuine technical advancement over the existing knowledge. Then only invention is considered as patentable and having an inventive step. The third criteria is, as I just explained in previous slide, industrial applicability, which means that the invention should be capable of industrial application and it should satisfy the following conditions, which are that the invention can be made in some industry, it can be used in at least one field of activity, and it can be reproduced with same characteristics as many times as necessary. So novelty, inventive step, and industrial capabilities are the three important criteria which an invention should meet for becoming eligible for grant of a patent. So ये तीन criteria mandatory हैं, but there are certain exemptions in the Patent Act according to which even though the inventions may be novel, inventive, and have industrial applicability, yet they are not considered as patentable subject matter. मतलब which means that there are certain exemptions provided in the act where invention meet the criteria of patentability, yet they are not considered as patentable subject matter. The first is anything which is frivolous or obviously contrary to well-established laws of nature. Anything which is frivolous inventions are not patentable. For example, if somebody says, I have made a perpetual motion machine which gives 100% output, so it may be considered as contrary to the laws of physics or other existing laws, so it may not be granted a patent and it may be considered as a non-patentable subject matter. The second category is the category of inventions whose primary or intended use is contrary to public order, morality, or which may cause serious prejudice to humans, animals and plant life or health or the environment. तो कुछ भी चीज जो public order के against है, morality के against है, such inventions are not considered patentable. So if somebody says, I have made an apparatus which can help in theft or which can commit injury to human beings, तो ऐसी कोई machine को पेटेंट नहीं ग्रांट किया जाएगा जो चोरी करने में या जो है लोगों को परेशान करने में के लिए यूज की जा सके, या any method of adulteration of food will be considered as contrary to public order, so it will not be granted a patent. The third category is mere discovery of scientific principles or formulation of abstract theory or discovery of living or non-living substances occurring in nature. This will be of importance to your work, the kind of work you guys are doing. So if you are merely discovering a scientific principle, it will not be granted a patent, because patents are not granted to principles, scientific principles or theories. They are granted to their application. आप उस scientific principle को apply करके कुछ product या process बनाएं, then that will be granted as a patent. But a scientific theory or a formulation of a scientific theory will not be granted a patent. Theories को, abstract theories को patent नहीं grant किया जाता है. Things which are already existing in nature, living or non-living substances, are not considered as patentable, because whatever exists in nature belongs to everybody. उसको हम पेटेंट नहीं करा सकते. सो अगर आपने सॉइल में से कुछ माइक्रो ऑर्गेनिज्म आइडेंटिफाई कर लिए या कुछ कोई केमिकल कंपाउंड निकाला कि जो है, so you will not be granted a patent to that compound or those organisms, but you will be granted a patent for the process of extraction. Process of extraction को आप patent करा सकते हैं, because that process was not known process, but the compounds which you will extract, किसी पेड़ से आपने कुछ compounds extract, natural products extract किए, you will not be granted a patent to those products or compounds. Then fourth and the most important, and in India this is the most notorious section, which says mere discovery of a new form of a known substance, which does not result in enhancement of known efficacy of that substance, or mere discovery of a new property or new use of a known substance, or mere new use of a known process, machine or apparatus, unless such known process results in a new product or employs a new reactant. It means that mere discovery of a new form of a known substance is not allowed. It is considered that this new form is the same substance as already known substance. So for example, if you have made some polymorphic forms of a known substance, so it will not be considered as a patentable invention unless you show that this new polymorphic form has improved or it has significantly different enhanced therapeutic effect. Until and unless you will not show that enhanced effect, enhanced efficacy, it will be considered as the new polymorphic form will be considered as the already existing substance, and it will not be granted a patent. Or if you have discovered new property of a known substance, आपने किसी substance की new property identify की. For example, if We know aspirin is used as an analgesic. If somebody says, I have used aspirin for cardiovascular problems, cardiac arrest, and this is a new property of this known compound. So it will not be considered as a patentable invention unless we are able to show that there is an improved effect, enhanced effect as compared to the existing knowledge. Similarly, new use of a known substance is also not allowed. New use of a known process is not allowed unless you show that your process results in a new product, or it employs at least one new reactant. आपको उस process में कुछ नया reactant show करना पड़ेगा, या same process, old process must result in a new product. The fifth is mere admixtures. If your invention is resulting in a mere admixture, you have taken two substances and only mixed them, you are admixing them, then admixtures are not considered as patentable subject matter. For example, if you are taking sugar and you have taken some colors and you are adding it into water and you say that I have come up with a new drink, then such drink will not be allowed, because water is showing its own property, sugar is giving its own sweet taste, and the colorants are giving their color. So it is a mere admixture. Anything which can be separated, any composition which can be separated by physical means are considered as admixtures, so they are not allowed under the Patents Act. However, synergistic compositions, a composition where components compositions where components of the composition show synergistic effect and they do not show their own effect but a combined synergistic effect, such compositions are considered as patentable compositions. For example, soap, detergents, lubricants, polymer compositions, these are considered as synergistic compositions. Next category is mere arrangement or rearrangement or duplication of known devices. मतलब दो चीजें already known है, आपने खाली उनको arrange rearrange कर दिया या duplicate कर दिया. Such inventions are not considered as patentable inventions. For example, if you combine umbrella and put a torch at its top, so torch is doing its function of throwing light, umbrella is doing its own function of protecting from water. So this is considered, it will be considered as duplication of known devices, because दोनों ही devices अपना अपना काम कर रही हैं, so therefore such invention will not be allowed. Next, the method of agriculture and horticulture. So methods which relate to agriculture or horticulture are not considered as patentable subject matter. However, if you come up with a method of producing an improved soil, then such methods can be protected because you are preparing an improved soil. Any kind of medical, surgical, curative, prophylactic, diagnostic, therapeutic, or other methods of treatment of human beings or animals is not considered as patentable. This provision has been brought in to provide good health services to the people of the country. Therefore, any sort of medical process is not allowed in India. Methods of treatment are not allowed in India. Plant, animal as a whole or part thereof are not patentable. However, microorganisms are patentable. So genetically modified organisms are patentable in India. But the plant parts, animal parts, they are not patentable. Mathematical business method or computer program per se are not patentable in India. Literary, dramatic, musical or artistic work are not patentable. You can protect them under copyrights. Mere schemes or rules or methods of performing a mental act or playing games are also not patentable. You can protect them under copyright. Presentation of information is also protected under copyright. Topography and integrated circuit, we have a different act altogether. and any kind of traditional knowledge is not patentable in India. India has, in fact, CSIR has made a traditional knowledge digital library where we can check whether our invention relates to traditional knowledge or not. So any kind of traditional knowledge is not patentable in India. Inventions which relate to atomic energy are also not patentable in India, and they are not granted as patent. So that was all about what are the three criteria of patentability: novelty, inventive step, and industrial applicability. And then there is a list of what inventions are not patentable in India. So before we think of filing a patent, when you have an invention in your hand and you are considering to file a patent, first do a novelty search, prior art search, to determine whether your invention is novel. उसकी ऐसा कोई काम, similar काम किसी ने पहले तो नहीं किया. If somebody has not done similar work, you also understand that invention is not obvious to people skilled in the art. Similarly, known चीजें available तो नहीं है knowledge में, prior art में, and your invention is patentable. And also check the list of exempted subject matter. आप ये check जरूर करें, check that whether your invention lies in any of these exemption or not. आपकी invention कोई admixture तो नहीं है, whether your composition is an admixture or it is a synergistic composition, whether your invention, the compounds which you have made are already not known in the art. ये सब check कर लीजिए, उसके बाद ही patent filing. Just consider patent filing after you check the criteria and the exemptions. So the next step is, if you have done a prior art search, you think that your invention meets all the criteria, then you must consider filing the patent application. So now I'll explain how you will file your patent application and what are the stages of your patent application. So in India, we have 4 patent offices at Delhi, Kolkata, Chennai, and Mumbai. And these 4 patent offices cater to 4 jurisdictions of the country. So Delhi caters to the northern jurisdiction, Kolkata caters to western, Chennai patent office caters to the southern Indian region, and Mumbai patent office caters to the western zone, and Kolkata, sorry, I said west, it is eastern zone. So these are the jurisdiction. This is the basic patent process, although you must be feeling it as a very complicated chart, but the main stages are filing. The first stage is filing a patent application. सबसे पहले we file a patent application at the patent office. Then our application gets published in the patent office journal. I'll explain each feature in subsequent slide, but still I'll just give you an overview. The third stage is filing a request for substantive examination. Then patent office examines our application and issues an examination report. Then we have to reply to the examination report, which is there in the green box. And then the controller decides whether to grant the patent or not to grant the patent. Now I can explain these steps in detail in further slides. So basically the stages of a patent process are preliminary research, which you will do, and you can also, if you want, you can take a legal help, a patent agent's help to do a preliminary research. They can help you in determining whether the invention is novel, inventive, and hence industrial application. Then the second step is filing of the patent application at the patent office. Then the next step is your application will get published in the journal of the patent office, which is uploaded on the website of the Indian Patent Office. Then there is a step of filing a request for examination. Then the examination report comes. Then we file the reply to the examination report. Application gets granted, and then every year we have to pay the renewal fee or maintenance fee. Earlier in India, it used to take at least 3 years' time from filing till grant of the patent. But recently, I have got a patent application filed and granted within 6 months. So even in lesser than 6 months, we can file the application and obtain a grant. So now patent filing and grant has become very fast. Last year in September, I had filed a patent application and it got granted in March. So now I can just change this slide and we can write that we can obtain a patent grant within 6 months time also. So for conducting a prior art search, these are few free websites where you can do a prior art search for patents. You can use Indian Patent Office website for doing a search of Indian patents. You can also do a prior art search on US PTO, US Patent Office website, European Patent Office website. Apart from these patent search, you can also do a search in your libraries of your institute um, for scientific journals and publications. You can also apply common general knowledge, whatever common general knowledge you have in your field, with you can combine this common general knowledge with your the scientific journal or publications, whatever you have in your hand, and then you can determine whether your invention is novel, inventive, and has industrial applicability. Once you have done the search, you are completely sure that you want to go ahead with the patent filing, then the most important part of patent filing becomes writing a patent application. How you draft a patent application or write the disclosure of your invention in a techno-legal manner, and this techno-legal document we call as patent specification. So the main features or the main parts of this patent specification are title. So first of all, you will write a title, you will give a title to your invention. For example, if you have made some soil composition, so soil composition for improved moisture or something like that, you can make a title. So you have to decide a title for your invention. Then second step is, the second heading will be the background of the invention, where you will discuss the existing art. You will discuss all sorts of soil compositions available, what are their components, what are their uses, what are their drawbacks. So you will identify the drawbacks or limitations of the existing composition, soil compositions, for example. So you will say that already such and such soil compositions are available in the market, but they are very costly or they do not provide sufficient moisture or whatever. I'm taking an example of a soil composition for retention of moisture. So I'll explain by this example. So I can say that whatever prior art compositions are existing in the market, they do not provide sufficient moisture, or they provide only like 20% moisture or 30% moisture. They are very costly. They provide repeated application of composition in the soil, or there can be lots of limitations, and your invention is providing a solution to all these limitations or to some of the limitations. So therefore, आपने देखा, you saw that there are certain problems in the art, and therefore इसलिए आपने अपना नया soil composition बनाया और ये आपने invention की. Because जैसे हम we say that problem is the necessity of invention. So अगर कोई problem exist करती है, so then only there is an invention. So basically, in the background, we have to write that there was a problem and my invention is providing a solution to that problem. Then you will define your invention in summary of the invention, and then if you will have to describe your invention in detail. So describing invention in detail means that you have to describe each and every feature of your invention. एक लाइन में, 2 लाइन में आपको एक्सप्लेन नहीं करना है. आपने जिस हिसाब से, जिस थॉट प्रोसेस से इन्वेंशन को conceptualize किया, the way you have conceptualized your invention, the way your invention works, the way your invention will be applied, the way your invention will provide results, everything has to be described in detail under the heading detailed description of the invention. You have to also explain different embodiments. अगर आप कुछ variation कर different variants बनाना चाहते हैं of your invention, of your composition, for example, So you have to explain all the embodiments of the invention. You have to provide preferred embodiments जो आपको लगता है कि ये exactly embodiment work करेगा. Best method of performing the invention. You will have to provide several examples to show how the invention will be worked. So the description of the invention has to be in such detailed manner that someone else, a third party, even if that person reads the patent specification, he is able to perform the experiment in the, so invention has to be extremely detailed. That is why it is called as detailed description of the invention. Then you will have to provide a series of examples to illustrate how the invention will work. Then you will provide drawings and abstract, and the most important part, which is point number 7, which is claims. So claim is the part of the patent specification for which you will be granted the patent. So claim is what you are claiming. आप क्या claim कर रहे हैं? I am claiming a soil composition which provides excellent which has excellent moisture retention properties. The composition comprises, this composition it comprises component A, component B, component C. So I am claiming my composition and I am claiming what I have made. So claims is the most important, most critical part of the patent specification. And it needs to be written very meticulously so that you get the best protection. Then you have written your application, then you will think who will file the application or in whose name the application has to be filed. So the patent application can be filed by true or the first inventor or his legal assignees. For example, if you are working in an institute of ICAR, so ICAR is the employer and the legal assignee. So all the applications will be filed in the name of ICAR. And you will be considered as the inventors. So your name will come under inventors and the applicant will be ICAR. So all the patent applications are submitted at the Indian Patent Office. The date on which you file your patent application is called the date of filing. So your date of filing is very important because all the cutoff dates are considered from the date of filing. So all the prior art will be considered before the date of filing. So if in India, the first to file is very important. So filing date becomes very important and very critical. So when we are filing a patent application, we basically require following documents. The first document is the application form, which is application form number 1, which has the details of the applicant, inventor, title, and other information of the relating to the application. Then the second form 2 is the patent specification. Either you can file a provisional or a complete patent specification that comes with the form 2. Then you have to file the drawings. You need to file form 5. If you are engaging some patent agent, then you need to provide a power of attorney to the patent agent. And if you have filed your application outside India also, then you need to file form 3 and provide the details of the foreign applications. In India, fees depends on the number of priorities claimed, number of claims. First 10 claims are free claims and 11th claim onward, there is an additional fee. Then filing fee also depends on the number of pages. So first 30 pages are free pages and after 31st page, additional fee is filed. Individual startups, small entity, so the nature of the entity, ICAR comes under large entity, so we have to pay the fee of large entity for ICAR institutes. However, if for universities, we pay for individual fee. There is a subsidized fee for universities, but institutes which come under ICAR, they are considered as large entity. So once you have filed your application, so from the date of filing, 18 months आप count कर लीजिए. So for 18 months, nothing will happen in your application. your application will remain at the patent office in a black box. Nothing will happen. वो पड़ी रहेगी वहाँ पे. Nobody is going to open it. After completion of 18 months, your application will get published in the journal of the patent office. Patent office का journal जो छपता है उनकी website पे. Every Friday this journal is published. So your application will get automatically published in the journal after 18 months. But लेकिन if you want your application, you do not want that your application should remain there for 18 months. कुछ ना हो, you want the processing your application to be expedited, then you can file a request for early publication. आप एक form 9 पे request for early publication file कर सकते हैं so that your application gets published early. Otherwise 18 महीने कुछ नहीं होगा. So once the patent application gets published, we are required to file. The next step is to file a request for examination. So like we have filed an application और वो publish भी हो गई है, so everybody comes to know about the publication. Publication is an important event in the prosecution process of the application, but patent office will not do anything in the application unless you file a request for substantive examination. तो जब तक आप ये request नहीं file करेंगे, patent office examination शुरू नहीं करेगा. So it is very, very important that we file request for substantive examination because examination serial order में होता है. In the order there is a queue, and when you file a request for examination, you will be allotted a serial number और examination serial number में होगा. तो जितनी the early you file the request for substantive examination, उतनी जल्दी आप लाइन में लग जाएंगे. So better है, although अभी recently rules have changed, so now from 48 months it has become 31 months. So we have to file request for substantive examination within 31 months from the date of filing of our application. और जितना जल्दी file कर ले उतना अच्छा. So once you file a request for substantive examination, patent office will examine your patent application on two main grounds. वो two parts में आपकी application examine करेंगे. One is the formal grounds. They will check the formal requirements. कि आपने सारे forms properly जमा कर दिए हैं कि नहीं. You have filled all the forms properly. You have filled all the documents, filed all the documents on time. So that is formal requirement. Then the second part of the examination report is the substantive examination, where they discuss the technical issue and the technical subject matter of your invention. They will check the novelty of your invention, whether your invention is novel or not. They will also check whether your invention is inventive or not. So they will, as you have previously done a prior art search, patent office will also do a prior art search. They will also do a search. They have lots of databases available with them, and they will do a search, and they will identify documents which are similar to your invention, and they will raise issues against your application and say that your application is not novel because these documents were already known. This information is already available in the art, or your invention is a mere improvement, or your invention lacks inventive steps. So they will raise such kind of questions, and then they will write them in a first examination report. In India, we use the term examination report. Foreign countries use the term office action. So they will issue a first examination report with all these objections, and they will send it to us, and we have 6 months time to reply to this objection report. So we will read the objections, we will read the documents, we will then prepare our reply that why the objection of the controller is wrong, incorrect, why their understanding was about the invention was not proper, and what is your understanding why the documents which controller has mentioned are not same or similar to our invention, how our invention is different from the objections of the controller, and it should be granted a patent. So we will file a reply. So once you file a reply, controller feels that it is okay, your invention is patentable, he will grant the patent. Sometimes they feel that they need a personal discussion, so they can issue a hearing also. So they generally ask us to attend the hearing, so then they verbally discuss the invention. since ICAR is a government, comes under government, so the applications filed by the ICR Institute get the benefit of also choosing the expedited examination route. So आप एक expedited examination भी request कर सकते हैं. As I mentioned, I got a patent within 6 months time. So for that we use this expedited examination route where applications are examined in a separate queue. There is a separate queue for expedited examination. तो आप भी इस process का use कर सकते हैं. So examination report, I have already explained that it has formal part and substantive part. In the substantive part, they will raise question on the novelty of the invention, inventive step of the invention. They will also say that your subject matter, your invention falls in the exemptions, exempted subject matter, exempted list. So we have to just explain everything to them how that our invention should be patented. Once the controller is convinced, he will grant the patent. And the grant is notified in the patent journal, which is published at the patent office website. As I have already discussed, the rights of a patentee are to exclude other people from making, using, offering for sale, selling, or importing the products, patented products in India, or if the invention is for the process. And if the invention is for the process, then उस patented process से जो product बनता है, that you can stop other people from making, using, or selling. So term of patent in India is 20 years from the date of filing of the application. So that is why we say that date of filing is very important. The earlier you will file, you will have a 20 years period from date of filing. Once the patent is granted, then after the grant of the patent, we have to pay the renewal fee, which means that every year we have to renew our patent. हर साल हमें patent renew कराना पड़ेगा for the next 20 years. So हमें हर साल अगर if we want to make keep our patent alive, active, then every year we will be required to pay the renewal fee. Thank you. This was a very brief explanation about the patent system in India, how patent system in India is working, and how you can start thinking of considering to file your patent applications.
Thank you, ma'am. Thank you for your lecture. If any questions are there, a few questions we can.
May I?
Yes, sir. Yes, sir. Please.
Thank, thank you, madam, for your nice presentation and very crystal communication to regarding the patent. Madam, I have a two question.
Yes, sir.
Not question exactly. It's just for discussion like that. Suppose someone has patent filed the patent. In the meantime, the similar kind of things someone also invented and came into market. So parallel two things, one is filed, it is just filed, and someone is similar kind of product and it come into the market.
Mm.
So what will be happen the file patent?
So there are 2-3 scenarios in this question itself. For example, if you have already filed a patent and your application is published, ठीक है?
Hey, that is required 18 months.
After
In the
18
meantime,
months.
yeah, in the
So अगर
meantime, someone
if after publication that person makes the same product and sell in the market, then it is a clear-cut infringement. In that case, you can file an action against that person and he will be stopped by the courts. ठीक है sir? But if you have filed a patent application and your application is not published, तो अभी आपके patent file होने का किसी को नहीं पता. Nobody knows about that patent. And in that meantime, other person starts selling similar product. So उस period के दौरान उसको वो infringement, it will not be considered as infringement. After publication of your application, still he continues to sell the product, then it will be considered an infringement. But during the period of non-publication, during the period of जहाँ पे publication नहीं हुआ जितने period में, वहाँ पे infringement नहीं माना जाएगा सर।
Okay, thank you, madam. Another मैम क्वेश्चन, जैसे हमने बता रहा है, जैसे आपको यू हैव टू गिव फॉर 20 years एज ए सम maintenance fee for the
हाँ
patent
हाँ।
once you get. So this amount is fixed or that is based on the product, what kind of things you are.
नहीं sir, that amount is fixed in the act, and but this amount changes after every 4 years sir. तो ये फिक्स्ड अमाउंट है, एक्ट में ऑलरेडी गवर्नमेंट भी मेंशन्ड है। तो सब पहले के सालों में जो है पहले 4 सालों में 4000 फीस जाती है, 4000, देन अगले 4 years 12000 जाती है, देन नेक्स्ट 5 years 24000 जाती है, एंड देन नेक्स्ट 5 years 40000 जाती है। So that is a fixed amount, sir.
Okay, thank you, ma'am. Thank you.
Hello, ma'am. Good afternoon. This is Dr.
Hello,
Vidisha.
sir.
Thank you for your elaborative presentation and description about the patenting process. मैम मेरा एक क्वेश्चन था, मैंने 2023 में एक डिजाइन पेटेंट फाइल किया था जनवरी में, और उसका स्टेटस अभी दिखा रहा है कि एग्जामिनेशन रिपोर्ट हैज बीन जनरेटेड सिंस लॉन्ग टाइम। मैडम इसमें कितना टाइम और लग सकता है, या अभी जैसे इसको स्पीड अप करना है तो उसके लिए क्या करना चाहिए मैम?
सब अभी यहाँ पे ना थोड़ा कंफ्यूजन हुआ, योर क्वेश्चन is a little confusing whether you have filed a design or a patent.
Design, madam.
Yeah, industrial design is a different IP and patent is a different IP.
This madam design.
हाँ तो डिजाइन है, एंड इफ योर स्टेटस इज ऑलरेडी शोइंग एग्जामिनेशन रिपोर्ट जनरेटेड, सर डिजाइन की और टाइमलाइन छोटी होती है, तो आप अपनी एग्जामिनेशन रिपोर्ट चेक करें कहाँ है, क्योंकि अगर उसका टाइम पीरियड निकल गया तो आपकी एप्लीकेशन भी अबैंडन हो जाएगी। तो अभी आप बहुत जल्दी देखें, आपकी तो एप्लीकेशन बहुत नैरो मार्जिन पे चल रही है, इफ द एग्जामिनेशन रिपोर्ट हैज बीन जनरेटेड।
So from madam where I can check the status?
तो वो वेबसाइट पे ही जहाँ पे आपने ये स्टेटस चेक किया है वहीं पे एग्जामिनेशन रिपोर्ट भी मिल जाएगी।
Okay मैम।
आप
Because
मतलब अभी ये वेबिनार के बाद तुरंत चेक कर लीजिए, क्योंकि उसका टाइम होता है, वो 2-3 महीने का आपको टाइम मिला होगा, अगर वो निकल गया तो फिर बहुत दिक्कत हो जाएगी।
But I couldn't receive any mail or any information. Just this status is showing since long time. So I was waiting that it will be converted in another
तो
status.
आपने जो भी एड्रेस दिया होगा, अगर ईमेल एड्रेस दिया होगा तो ईमेल पे आई होगी, और अगर आपने ईमेल नहीं दिया होगा तो वो लेटर आया होगा।
First they asked some queries, so we have replied through the official process.
कोई बात नहीं सर, वो एग्जामिनेशन रिपोर्ट, इट इज मैंडेटरी टू रिप्लाई टू एग्जामिनेशन रिपोर्ट। अगर आप रिप्लाई नहीं करेंगे तो वो ये मान लेंगे कि आप इंटरेस्टेड नहीं है, वो फाइल को अबैंडन कर देंगे, बंद कर देंगे।
और मैडम सेकंड मुझे एक जानकारी ये लेनी थी मैडम, ये जो हमारी एनुअल रिपोर्ट होती है इंस्टीट्यूट की, क्या जो पब्लिश होती है इसको भी पेटेंट के लिए फाइल कर सकते हैं?
नहीं सर, वो तो आपका लिटरेरी वर्क हो गया, एनुअल रिपोर्ट को आप कॉपीराइट करा लीजिए।
ओके, थैंक यू थैंक यू।
Excuse me.
Rajan sir,
जी
Rajan.
सर।
Madam, good evening.
हेलो सर।
Madam, very nice presentation. Very elaborative lecture. We got very good clarity on your presentation. Madam, my doubt is, suppose I selected a material, I heated for a particular temperature, I kept it for a particular time. Then this material has become one product. So now second, can I go for product patent or process patent separately?
So you can, if your product is novel inventive, then you can go for product patent. If your process is novel inventive, you can go for process patent. If
Okay,
both
ma'am.
are novel and inventive, then you can go for both together. Same application में product भी मिल जाएगा, process भी मिल जाएगा।
Okay, madam. Okay, thank you.
Srimali sir, please.
Good afternoon, ma'am.
Hello sir.
I just wanted to know, two BTech students are working on developing some sensor-based device at our institute. They are using available sensors from the market, but the sensor data is being modified and transmitted by writing a code by themselves. So can they file a patent for that process of transferring the data from sensor to a design platform by them? Because this will be a new process,
Yes,
and
sir.
it has
Yes.
a industrial applicability also. If it is made as a total device to get the field data on a web platform, so is it patentable?
Sir, that can be patented.
Because they are working on that, so I was looking from that point of view.
Sure, sir. बिल्कुल वो patent हो जाएगा, sir.
Thank you. Thank you.
Ma'am,
Ji.
with continuation with the question similarly sir asked, actually suppose something we are purchasing from the market, sensor and some many other component from the XYZ spare part, okay, and we are compiling and we are making some instrument or some device which is not existing or presently available in the form of we are developing. So can we able to file
हाँ
the
जी सर,
patent
आप
and
तो
which
पेटेंट
component?
नई डिवाइस पे लेंगे ना, आपको पेटेंट उन प्रोडक्ट्स पे थोड़ी लेना है जो मार्केट से खरीदे। कोई भी रिएक्शन आप करेंगे अगर, तो आपको केमिकल तो बाहर से लेने पड़ेंगे, या आप कोई मशीन बना रहे हैं तो आपको पार्ट्स तो बाहर से लेने पड़ेंगे, बट आप उनको अरेंज करके कंपाइल करके आप जो नया प्रोडक्ट बना रहे हैं वो प्रोडक्ट नॉवल होना चाहिए, वो इन्वेंटिव होना चाहिए।
Okay, thank you ma'am.
Any more question, please? If no, I request Dr. M. Murugan sir to give his final remarks. Dr. OIC PM sir, please. Muruganandan sir.
Good afternoon, Dr. Anupam Bar and our today guest speaker, Dr. Vidisha Garg. And it was very excellent narration of the IP and particularly patenting. And patenting के बारे में कितना भी पढ़ेंगे सुनेंगे, it would be less only लग रहा है. So we have been listening, but your presentation gave a lot of clarity, and you had a very composed and clear and comprehensive picture of patenting, all that, and filing process and novelty, and starting from novelty and obviousness and kind of industrial applications, and drawing references and examples from many different fields, starting from kitchen to kitchen salt to again machine based on motion law, and hairpin also you cited examples with which we could understand, with which we could have a better clarity and comprehension on patents and patent filing, all that. And sure, our scientists and our colleagues definitely would get benefit out of this presentation, and your presentation will also be in our website for our reference and our reference of others also. And we enjoyed your composed speech and very clear-cut communication, and without any hinge. And the whole 1 hour we did not know how it went, and with a lot of fun, full of information, and with which we will have a long-lasting association. We will continue to interact within this front.
Sure.
And probably if you can give, or if you can suggest, or if you can act as a kind of legal authority or legal agent to process our patents and our records, our IP products for filing, it would be good, because our scientists and our institute develop a lot of product and process, and with but only requirement is like the prior art search and kind of drafting a patent filing details is little requiring art and time also. And if you can find yourself, get associated with us, it will be, we will be benefited from your rich experience and association. And unhinged experience will benefit our institute to get many more patents. And we are just beginning, and we are having a few patents and IP products to our credit also, but that is lesser in number as compared to our effort we are putting in. And in coming days, I think we hope we will have many more. and our scientific team is very actively engaged in finding out research solutions for natural resource management, and they have got a lot of process and product in their research activities. And this your presentation definitely going to give us a lot of insight and kind of enthusiasm to file patents and new patents. And with which we thank you immensely for your time and sincere effort of giving knowledge. And we wish that you continue to be in our contact and our communication.
Sure.
We will approach you for our support. And with which I thank our scientist colleague who are actively participated and clarified their doubts, and our director who has very sincerely and very cordially has consented to have this workshop on the event of Intellectual Property Awareness Week. Because as I said, whatever, however length we listened and read and heard, which would be lesser in this area only, because every year new aspects are being added and something new is being added to which we should be abreast. And with these, I thank one and all, and special thank to our young colleague, Dr. Anupam. He could find you and get to connect with us. It's really good. And yesterday also I listened to our professor, and it is a little better than the yesterday's presentation. We got many practical tips and guidance, which is going to help us in years to come. Thank you. And I think we would wish you all the best, and we wish also to be in touch with you then. Thank you, ma'am. Yeah.
Thank you, sir.
Thank you, sir. Thank you. I want to inform you that Madam is already associated with us, sir, because we are already doing one patent. She is helping us a lot in that. And this we are many more we have patent in that category, because clarity was not there, and now Madam has given a lot of clarity regarding, because we are also facing some process patent was very tricky one, and now process patent we can file. So thank you, sir. And
Okay, all right.
I thank council, our director, sir, all HODs, heads and section, and also our chief guest today, Madam Vidisha, for giving us a beautiful lecture. I also thank all our scientists, technical staff, and YPs joining through different platforms. I also thank entire divisional faculty, staff, and support staff, especially from administration side and from IT side, who made this platform visible for all. So I thank you, and this is all for today. Thank you, madam. Thank you. Thank you.
Thank you, sir.
And finally, thank you to you.
Thank you. Thank you, sir.
Thank you, Anupam.